I'd like to welcome you all to our final session for the term of the Oxford Political Thought Seminar. And we're delighted to have two very distinguished speakers from, actually both from across the Atlantic. One of them's been kind enough to drop in to Oxford and spend a few years with us. So we have with us Mohammad Fadel and Lena Salaymeh. Mohammad will be going first, so I'll briefly introduce him and his lecture. I'm Usaama al-Azami. I'm a departmental lecturer at St. Anthony's College, and Faisal is really the brains behind this. We're co-conveners for the Oxford Political Thought Seminar. So Faisal Devji is Professor of History at St. Anthony's College. And it gives us great pleasure to host you all. We want to remind you that this is going to be a seminar where the speakers speak for about 20 minutes each. And we welcome people's questions. Please type them up in the Q&A and we'll try to address them in the discussion that we'll make for the last half of the seminar. So Mohammad Fadel is a full professor and former Canada Research Chair for the Law and Economics of Islamic Law at the University of Toronto's Faculty of Law, where he joined in January 2006. He has a PhD and a JD. His PhD was from the University of Chicago on the legal process in medieval Islamic law. He's also practiced as a lawyer in the city of New York, and so admitted to the bar in New York, but has been a prolific author on the law and at the intersection of Islamic law. Also, of course, as we've discussed, Islamic legal procedure, but also, you know, it's your engagements are quite wide-ranging. So you've also done political theory, history of political theory, and today you're here to speak about the Protean sovereign of Sunni law. So we're very much looking forward to that. Mohammad, if I could invite you to speak for 20 minutes. Thank you.
Thank you very much, Usaama. Thank you very much, Faisal. It's a great pleasure to be here. Faisal and I were classmates way back when in Chicago, so it's great to see him. Wish I could be in person. Lena, of course, I've known forever, so it's wonderful. And just to clarify the record, Lena is a Jerusalemite. She's not a native North American, so I just want to make that clear to everybody. So let me share my screen. Okay, so
Lena's also opposed to identity politics and doesn't believe that that should have been stated. Let's state that for the record very clearly.
Yeah. Okay, let me see if I can get this right. Okay. The Protean sovereign of Sunni law. What, you know, sort of a strange title, but I chose it because I wanted to frame what I consider to be really a central feature of the way Sunni jurists write about the state and sovereignty. And the idea of Protean captures it because it's very difficult to capture sort of the locus of sovereignty in Sunni constitutional writing. And I think this is a very important idea to grasp, not only the ambiguity in legal writing, but the reason why. There's a principled reason why is very hard to capture it in a clear term in Sunni law. So I'm going to begin by just pointing out, you know, Wafat Wahba's translation of Mawaridi's Al-Ahkam al-Sultaniyya, and this is not to pick on her, but she translates the first chapter, Fi Aqd al-Imama, as on the appointment of the sovereign, the Imam. So I think this is a very common assumption among writers in Islamic political theory that, well, the caliph is the sovereign. And so we are just going to assume that, and we will approach writings on public offices from that perspective, right? And I think this is a very sort of casual analogy between the caliphate and the kingship, European kingship or British kingship, which is completely unjustified once one looks into the details of Islamic law. So as we're probably familiar in British doctrine, you have this very sort of strange metaphysical theory of the king's two bodies. And I don't know all the details of the the genealogy, the theological genealogy of this doctrine. But even as late as the 17th century, it is fundamental to understanding the authority of the British Crown. And it's fundamental to very basic cases of English constitutional law that end up being very important in American constitutional law, for example, Calvin's case, right? Now, what I want to try to say, in Sunni fiqh, there is not a problem of the caliph's two bodies. And there's a reason for this, which I'm going to get into. But the solution just means that we don't have a tangible, personalized expression of sovereignty in Sunni jurisprudence. That's what makes it Protean, because it shows up all over the place, right? That's basically what I want to say. So if we look at early legal texts, and here I'm talking mainly based on my knowledge of early Maliki legal texts, such as the Muwatta and the Mudawwana, you come across all these different terms. You can come across Khalifa, Imam, Sultan, Qadi, Wali, Hakim, Amir, etc. And all of these terms are used in connection with the exercise of what we would call sovereign power. And what I mean by sovereign power is the power to decide something finally and to give a conclusive resolution to something, right? And so Malik and early Madinese legal authorities use these terms interchangeably, willy-nilly, right? In fact, Khalifa oftentimes is the least political of them. So if you do a quick search of Khalifa in the Mudawwana, most of the occasions, I believe, are in prayer, where the prayer leader, something happens to him, he can't complete the prayer cycle, and so he appoints a Khalifa to complete it, right? But nevertheless, Khalifa definitely has political resonances, but it doesn't monopolize in any sort of sense an idea of sovereignty. The equivocal terminology or the variable terminological language used to describe sovereignty is very nicely reflected in this one very short text, right? Where you get multiple terms for a very simple problem, right? So Sahnun asks Ibn al-Qasim in the Mudawwana, what's your review regarding the rulings of the governor of Fustat? So he calls him first al-Wali, right? And what he's doing is hakama, right? And then he calls him Amir al-Salah, right? Which, we might later call the imam, right? The sort of the prayer leader in the sense of imam. So then he asks, are they valid and effective to the same extent as the decisions of judges in Malik's view? So now we get the term qada, plural of qadi, right? And so Ibn al-Qasim says, yes, unless his decisions are manifestly unjust, in which case the judge can repeal them, right? And on what grounds does Ibn al-Qasim reach this conclusion? Again, it's very interesting for understanding the implicit doctrine of sovereignty here. He bases it on an analogy to arbitration. Malik was asked about two men who appointed a third to arbitrate between them, and then he did. Malik said, I believe the judge should enforce the arbitrator's decision in their matter and not overturn it unless it was manifestly unjust, right? So what we see here, or what I would argue here, is that sovereignty as expressed in legal decision finds its origin in the decisions of individual people to delegate authority to others to rule on their behalf, to make a judgment on their behalf, right? Now, this is not a purely positivistic delegation in the sense that it's a matter of whatever the ruler decides is proper, because exercise of sovereignty, as Malik conceives it in this case, is regulated by a norm. So the arbitrator's legitimate sovereignty is a function of two things. It's a function of the consent to his status as arbitrator and a function of his substantive decision not being manifestly unjust, right? And so this same principle, consent plus legality, right, regulates all these offices and regulates how all sovereignty is constructed. And by implication, right, sovereignty is exercised through this mechanism. And that's why you have multiple offices exercising sovereignty, hence the Protean character of sovereignty, right? And this comes across very explicitly, and I think theorized very nicely in the work of Shihabuddin al-Qarafi that I translated, the criteria for distinguishing legal decisions from opinions, etc. Right? And so he deals with this expressly in his answer to question 33, where he says, public offices exist across a spectrum of powers with two extremes in the middle. The office of the caliph, which is the greater imamate, that's the office with the greatest power. Arbitration, which comes into existence by an act of the two disputants, is the office with the least power. And between these are many intermediate offices. And he then gives 15 examples. And his point is all these different offices all exercise sovereignty in the sense that I talked about, namely having the authority to resolve disputes conclusively, right? And you can sort of systematically identify sovereign power through this range of what's the scope of sovereign power that each office has. So the Imam, al-Imam al-Azam, the Caliph, has the greatest scope, right? And that is reflected in the fact that he can do fatwas, he can act as a judge, and then he can act in the public interest. But what's crucial to understand in all these cases is that when the Caliph acts judicially, he must actually act as a judge, right? Because the principle that Malik asserted, or Ibn al-Qasim asserted, is that when the wali, the governor, issues a ruling, it's valid and enforceable, i.e. an exercise of sovereignty, as long as it's not manifestly unjust, i.e. it corresponds to the substantive idea of law. So although in principle the caliph has all the powers of lesser offices, in practice, his exercise of that power transforms him into a judge when he acts judicially, transforms him into a mufti when he acts as a mufti, transforms him into a witness when he acts as a witness, et cetera, et cetera, et cetera, right? So in all cases, there's never any sovereignty attached to his person, right? So his body, he does not have a natural body that is of any significance to sovereignty, right? Unlike the English king. Okay, so in that case, who is the sovereign, right? Where is the sovereign in Sunni thought? And so my argument is that the sovereign is a non-corporeal entity, namely the Muslim community, right? And so we see that expressly in this very interesting text of the Hanafi jurist, who's maybe a century before Qarafi, al-Kasani, Abu Bakr al-Kasani, died at the end of the 12th century. And here he's discussing why a judge does not lose jurisdiction when the appointing power, like the caliph, dies. Because one might think that the judge is the delegate of the caliph, and so he's a representative of the caliph. And normal principles of agency law state that when the principal dies, the agent loses all authority because the principal is gone now from a legal perspective. But he says that's not the rule for the judge. Even after the caliph dies or is deposed, the judge's jurisdiction remains valid. And the reason, according to al-Kasani, is because the judge is neither appointed pursuant to the personal authority of the caliph, nor does he act to further the personal jurisdiction of the caliph. Rather, in both cases, he's appointed pursuant to the authority of the Muslim community, and he acts for the Muslim community. And the Muslim community does not die, right? As he says here explicitly, where is it? وَوِلَايَتِهِمْ بَعْدَ مَوْتِ الْخَلِيفَةِ بَاقِيَةٌ. The wilaya of the Muslim community persists after his death. So what does that make the caliph? It makes the caliph an agent. But interestingly, it's not just any agent. He uses the term rasul, which in Hanafi fiqh is the lowest form of agent. He's the ministerial agent, the agent that has absolutely no personal interest in the transaction at issue. So there's no confusion from the perspective of the third party, whether he's dealing with the agent in his personal capacity or for the principal, right? So it's very interesting that for Kastani, the caliph is so unimportant that it's just a ministerial function. And in all cases, as he says, it's always the Muslim community that is acting. When a judge is appointed, it's an action of the Muslim community. When a judge is removed, it's an action of the Muslim community. It's never an act of the caliph haqiqatan, right? It's just through by means of, right? He's just a straw, so to speak. Now, one of the things I want to try to show is that this idea is pervasive, right? It's not particular to Kastani or Qaddafi or whatever. And so here's an extract from a 5th century Maliki work of positive law. Tabsira, the jurist al-Lakhmi is an important Qayrawani jurist, and he's talking about the idea of the rule of law as being obligatory, iqamat al-hukm lin-nas, right? This is a duty. Kastani, by the way, mentions the same thing if you look at Kitab al-Qada. And so the ruler has a positive duty to establish a system of rule of law. And of course, he can do this personally if he has the capacity, right? But again, it's qualified by having the capacity to actually establish an effective system of rule of law. Practically speaking, that's impossible. So therefore, he has an obligation to delegate to others power sufficiently to establish a rule of law, right? And then finally, what's interesting, tying this back to where we started with arbitration, what happens if he fails to do that, right? Or there's no ruler, right? Then he says, right, it devolves on those persons having good judgment and good character, and whosoever they agree is qualified to discharge that obligation, they appoint him to the post. Right? So again, here there's this idea that representing the Muslim community, as I would put it, is potentially not a stable, it's not stably located in any particular person. It's only located in the person that is exercising the legal duty or fulfilling the legal obligation. So what makes the wali a wali is that he establishes a rule of law, right? The wali who doesn't establish a rule of law is not a wali, right? So again, you can say this, that it's not, sovereignty is not the right to obedience. Obedience is what creates the sovereignty. So sovereignty is constituted through the act of obedience, not the other way around. Okay, so I will stop here. Thank you.
Thank you. Thank you so much, Mohammad. That was intriguing, fascinating as always, and nice to read some Arabic on the screen. We will come to those questions that viewers may have, and please feel free to type them up in the Q&A bar, and we will address them in the final half of the broadcast. I'd like to invite Lena at this point to give her presentation. So Lena is, I'm very happy to say, my colleague this year at St. Anthony's College, our colleague for Faisal and I, and she's a scholar who specializes in critical theory in relation to law and history, using interdisciplinary and critical methods to ask historical, historiographical, and jurisprudential questions of Islamic law and Jewish law in the late antique, medieval, and modern eras. And the two of you are wonderful to have on the same panel, especially because you're both historians with doctorates in that sort of area, but also legal scholars with JDs. And so I think this will make for a particularly illuminating conversation, especially since your approaches, I'm sure, will be dramatically different in it. And so I did want to highlight Lena's very important first book, The Beginnings of Islamic Law, Late Antique Islamic Legal Traditions, and which offers a historically grounded understanding of Islamic law. She is also very prolific, and I've noticed, Lena, you've been publishing quite a bit in the last year or year and a half. Really sort of at the cutting edge of a number of different fields. And her publications are available on her academia page. So I could go on, Lena, but I'm going to, at this point, ask you to speak on your sort of topic, which is sort of reconsidering the political in pre-modern Islam.
So thanks for the invitation to participate in the series. I'm looking forward to the discussion. Islamic political thought may be the most deeply politicized area of Islamic studies. In the global north, an inordinate amount of the scholarship revolves around asking the problematic question, can Muslims be politically modern? This question motivates research that examines Islam and democracy, or Islam and human rights, or any number of other similar modern political forms. Posing the question is incoherent because it is based on an essentialization of being Muslim and of being modern. Consequently, attempting to answer this question is an intellectual trap. I do not engage with pre-modern Islamic political thought with the objective of answering this false question or its corollaries. Instead, I ask different questions, and I would suggest, for instance, the question, how do Muslims in the modern era use the pre-modern Islamic tradition to articulate their politics? Rejecting the conventional question also results in discarding conventional answers. A primary conventional answer involves surveying the ideas of specific Muslims. Recent scholarship constructs a canon of modern Muslim political thinkers, including Rida, Qutb, Maududi, and more recently, Ghannouchi. This great men approach is a gross distortion because it misrepresents political thought as the product of certain famous men. And not coincidentally, this approach reflects the misogyny in the field of Islamic studies. Researchers who perpetuate the great men mythology misconstrue these prominent men as representative of the Islamic tradition's past or present. In the present, in an empirical sense, these figures do not epitomize the entirety of the modern Muslim world or its political thought. As for the past, these figures do not embody Islamic continuity. Too many researchers view the claims of these specific men as facts rather than as interpretations. In addition, much research separates theory from action, which is evident in how political theorists construct this canon of named men, while political scientists study Islamist groups of largely unnamed men. Both the question, can Muslims be politically modern, and the purported answer, this is how these famous men view modern Muslim politics, are unproductive. To understand modern Islamic political thought fully, we need different questions and different research heuristics. Pre-modern Islamic political thought can illuminate both alternative questions and heuristics. So in my comments today, I will begin to address two interrelated issues. First, how do we understand political thought in the pre-modern world? And second, how do we find political thought in pre-modern sources? Before we can engage with these two questions, we must be clear on our baseline concept. So I am using political broadly to mean matters of governance. In considering these two issues, I'm building upon the theories and methods I've delineated in my previous scholarship. I am not a political theorist, so I engage with pre-modern Islamic political thought through critical theory and Islamic law. Critical theory, of course, intersects with political theory, and law is political. So all of my scholarship previously has involved dimensions of Islamic political thought. So I want to begin by exploring how pre-modern Muslims conceptualize political belonging in legal texts. There is a consensus documented in late antique and medieval Islamic sources that all free, adult, and sane Muslims are recognized as subject to the charity tax on their wealth. Pre-modern Muslim jurists disagreed about the imposition of the charity tax on individuals without legal capacity, such as minors, and on individuals with questionable legal capacity and property rights, specifically slaves. If the late antique Islamic taxation system was based on membership in the polity, then wealth was the key criterion for tax liability. If the taxation system was based on belief, then intentionality to perform a ritual act was the key criterion for tax liability. Most late antique legal authorities obligated minors to pay the charity tax. Since Muslim minors were not expected to fulfill ritual obligations because they lack intentionality, most jurists viewed wealth as the prerequisite for the tax. By comparison, most late antique legal authorities did not require slaves to pay the charity tax. Since Muslim slaves were expected to fulfill ritual obligations, most jurists viewed wealth and political status as prerequisites for the tax. Simply put, many late antique legal authorities required minors, but not slaves, to pay the charity tax because political belonging, rather than belief or intentionality, triggered the obligation to pay. The legal reasoning underlining doctrinal rules about charity taxation reflect political thought. Many pre-modern Muslim jurists viewed paying the charity tax as enacting Muslim citizenship. I follow Elizabeth Cohen in recognizing that citizenship is a gradient category and not a binary one. Thus, there is a status in between citizens and non-citizens, which Cohen refers to as semi-citizens. Because the Islamic taxation system was, from the beginning, a means of taxing both members and quasi-members, it corresponded to a political framework for defining citizenship and semi-citizenship. Using the category of citizenship in the late antique context is not anachronistic, for those of you who may be thinking it is. Citizenship, like state, is not a fixed category, but one that has historically specific meanings. Consequently, late antique citizenship in a late antique state is distinct from modern citizenship in a modern nation state. Moreover, citizenship is widely understood as a category that is applicable in pre-modern contexts. So, for example, few people doubt the efficacy of the category of Roman citizenship. The fact that Romans are viewed commonly as citizens and Muslims as believers does not reflect concrete differences between what it meant to be Roman or Muslim in late antiquity. Instead, the tendency to characterize these groups differently reflects modern presumptions that are incongruent with the historical reality. Simply put, in late antiquity, being Muslim was a form of citizenship that established political belonging. Methodologically, my article taxing citizens' socio-legal constructions of late antique Muslim identity demonstrates how we can use a variety of pre-modern sources to reconstruct the political thought of jurists. Late antique legal opinions surrounding the payment of the charity tax reveal how jurists demarcated who is a Muslim, which in a pre-secular world was a political identity. So if we were to tell a macro story about governance in the pre-modern Muslim world, that story would narrate the growing power of the state and professionalization of the state's bureaucratic apparatus. Because the process of professionalization was gradual and incremental, the late antique period provides historical evidence for styles of governance that did not continue. For instance, rulers during the late antique period played a larger role in interpreting and in declaring Islamic law than rulers in successive periods. Obviously, Muhammad passed judgments over the first Muslim community in both Mecca and Medina. Likewise, the caliphs who succeeded him were not merely political leaders because they promulgated laws and shaped normative legal practices. There are numerous legal opinions associated with each individual caliph, and Caliph Umar is even known to have dismissed judges for implementing substantive legal decisions that differed from his legal opinions. Many Umayyad caliphs had some legal knowledge and were involved in the everyday practice of law. So, for example, there is historical evidence that early Umayyad caliphs held their own courts, offered judges their legal opinions, tested judicial knowledge, and dictated court procedural rules. Notably, the relationship between Umayyad caliphs and Umayyad judges was not exclusively hierarchical. So, for example, a Medinan judge ruled against the governor of Medina, Marwan ibn al-Hakam. Thus, there was competition, interaction, and overlap between rulers, judges, jurists, and other bureaucrats. We need to recognize and understand this historical evidence because it corrects a prevalent romanticization of pre-modern Islamic governance. According to this idealistic projection, pre-modern Muslim jurists were entirely independent of the state. This is inaccurate. As I've explained elsewhere, states have been involved in the shaping of Islamic law from the beginning. Despite the aspirations of pre-modern jurists, rulers endorsed legal schools, appointed judges, and had other broad-scale influences on the shape and substance of Islamic law. Of course, the modern nation state usurped the power of the jurists more extensively, but it was not the first form of governance to compete with jurists. Moreover, the romanticized narrative is a projection of European history and Eurocentric concepts. That is, many scholars implot their narratives of Islamic history in imitation of a European history of church versus state conflict. The church is represented as the ulama, an untranslated term that distorts the complex relationships among different types of scholars, jurists, judges, and other bureaucrats. This is another example of an untranslated term masking secular assumptions, a phenomenon that I identified in my article, Decolonial Translation. There are many implications for imposing a European model of church versus state controversy in pre-modern Islamic history. I'm only going to mention two here. First, much recent scholarship treats scholars like church clergy, and as a result, the scholarship conflates the Islamic tradition with the orthodoxy of a select group of scholars. However, Muslim jurists and scholars are not the functional equivalent of clergy. There was no church institution in pre-modern Islamic history, and scholars did not operate in a hierarchical structure. Second, this Eurocentric misreading of Islamic history leads to the mistaken classification of the pre-modern Islamic state as external to the Islamic tradition. In reality, rulers and scholars were competing groups within the Islamic tradition. So as we saw with the first historical example, an obligatory state-imposed tax that derives its legal validity from the Quran confuses modern legal categories. The pre-modern Islamic charity tax does not correspond to the modern bifurcation between religion and the secular. Pre-modern citizenship did not recognize a notion of religion. As we saw with the second historical example, the competition, interaction, and overlap between rulers, judges, and jurists defy modern governance's centralization. Conventional scholarship focuses on the scholarly class in ways that I describe as a secular translation of the Islamic tradition. Pre-modern Islamic governance does not correspond to the secular bifurcation between church and state. So when contemporary scholars research pre-modern Islamic political thought, they frequently limit themselves to dimensions of the Islamic tradition that the contemporary scholar understands as political, rather than to the dimensions of the tradition that pre-modern Muslims understood as political. So this is not simply a matter of anachronism. Pre-modern political thought was not secular. With these two brief historical examples, I illustrated how secular political thought distorts pre-modern Islamic political thought. It is important to keep in mind that how one understands pre-modern Islamic political thought has direct implications for modern Islamic political thought. Secular ideology constructs a problem space in which the secular modern nation state is constantly demarcating a line between politics and religion. This is not a line that can be drawn empirically. It is a line that the modern nation state draws and moves in accordance with its particular material and ideological objectives. So put differently, the modern nation state differentiates between two secular notions, secular politics and religion, because it serves its interests to do so. Secular ideology advocates certain political doctrines. First, secular ideology seeks to concentrate power in the institutions of the modern nation state. In some of my previous scholarship, I've demonstrated both how secular ideology defines religion as the non-secular and how this secular notion of religion muddles the pre-modern Islamic tradition. When secular ideology falsely demarcates certain aspects of social life as separate and distinguishable, it alters interrelated spheres such as ethics and politics. Second, secular ideology asserts that law can only be positive law because the state seeks to maintain power through univocal state law. The secular notions of religion and positive law distort Islamic politics. Now, in my experience, the historical and theoretical arguments that underlie the critique of secularism cannot be explained in a short talk. Understanding the critique necessitates extensive reading in the history of secularism and the genealogy of religion. That is the modern history of secularism, because that's the key issue. So rather than continuing to explain this critique of secular political thought, I just want to suggest the readings identified on the slide and move on. So when I began this talk, I asserted that much recent scholarship is motivated by asking the problematic question, can Muslims engage in modern politics? I want to return now to the question I posed as an alternative. How do Muslims in the modern era use the pre-modern Islamic tradition to articulate their politics? As is common in similar contexts, when contemporary individuals look to the pre-modern past, they see it through the lens of contemporary ideas and concerns. Consequently, many prevalent assumptions about Islam's past are reflective of Islam's present. This is not unique, of course, to Islam. Contemporary Islamists, though, and the scholars who study them frequently rely on a set of false assumptions about pre-modern Islamic political thought, and I presented two historical examples, Muslim belonging and the relationship between jurists and the ruler, that defy conventional assumptions. In addition, contemporary Muslims often make claims of authenticity or returning to the past that should be challenged because neither authenticity nor return are possible. In many cases, instead of authenticity or return, we find hybridity. In the specific case of modern Islamic political thought, we find what I have called secular Islamization. Secular Islamization is evident in how some Islamist groups adopt a modern secular notion of religion and imitate secular legal and political reasoning. I analogize this process to the placing of Islamic vocabulary in secular political sentences. This is, of course, again, not unique to the Islamic tradition. I hope that it is clear by now that what underlies the conventional question about the possibility of Muslims engaging in modern politics is another ineffective question: can Muslims be secular? As I've demonstrated elsewhere, this question motivates much scholarship in Islamic studies today. It is an analytically confused question because Islam and secularism are not mutually exclusive. It is a misleading question because it directs attention towards a circular path enclosed within secular ideology. In order to reconsider the political in the Islamic tradition, we must recognize that secular political thought is neither trans-historical nor transcultural. Thank you.
Fantastic. Thank you very much, Lena, and thank you, Mohammad. I think, we really have two wonderfully rich papers which talk both to each other and in some ways against one another. So we are open for questions. Members of the audience can write in their questions in the Q&A box or the chat box or raise their hands. And Usaama and I obviously will also ask questions. And I just have a couple to begin with. The one place where these two papers meet seems to be the claim, a very interesting claim about the non-linear nature of authority. And this can go in so many different places. So I just want to ask both of you, each of you, about that. For Mohammad, the fact that there seems to be no real hierarchy in which appeals can be taken from a subordinate authority to a superior one, do you think that suggests that sovereignty, as you define it, is fragmented because it is divided by the field that each authority encompasses? You mentioned, for instance, how the caliph can take on the role of authorities who are normally seen as subordinate to him. And in this way, his own authority gets to be divisible in field-like ways. Is that one way in which you might think about what appears to be a fragmented form of sovereignty? Perhaps another way of putting it is the Muslim community as the residual ground of this sovereignty is unable to manifest itself apart from in these varying authorities. You also said something about the distinction between, insofar as justice or legitimacy is crucial to the acknowledgement of the sovereignty of any authority, it seems to be more a kind of, if you will, ethical or even philosophical principle rather than the law. So three bits of questions which join together. And then Lena, if I might just ask you again, this category of the nonlinear nature, I think is, it's really, as I said, it can go in so many different places. And I just wanted to ask whether, without seeing it as being anarchistic in any way, though it would be interesting if it were anarchistic, how you might think about the anti-hierarchical or the non-hierarchical nature of authority. And then, since, with your first example, which had to do with property, how you might, could you say something more about how property or ownership or wealth ends up configuring citizenship in a way that that has not really been taken into account, as far as I know, in the scholarship on Islamic politics? I find that a really suggestive way of thinking, because it might allow you to approach sort of European political theory and its fixation on property in a quite different way. So, your critical endeavor addresses not just the question of secularity, which you rightly brought up, but also that of ownership and property, which defined so much of early modern and modern political thought in Europe. So sorry, rather shaggy dog questions. Mohammad, perhaps you can begin.
Yeah, I mean, I think I wouldn't necessarily say non-linear. That's not how I would describe it. What I would describe it as shared sovereignty. That sovereignty is shared throughout the community, through all these different offices, that these are coordinate offices, each exercising a particular slice of sovereignty. But that sovereignty is real in the sense that it doesn't depend for its vigor on the approval of the appointing authority. Because the appointing authority isn't sort of like, the caliph isn't appointing the judge in the way that I appoint somebody to build a deck for me, right? This is the point of Kasani. Kasani is saying he's acting as a messenger of the community to fulfill this function of discharging the rule of law, right? And so that's a real sovereign function that now exists in the judge. And so when the judge exercises that lawfully, then that's a full act of sovereignty, not dependent on the caliph's will in any sort of way, right? Likewise, the caliph has personal capacity to adjudicate disputes, but that's not because he's superior. It's because he's taking on the trappings of being a judge. In some sense, he's descending to the level of a judge when he wishes to do that, right? And so I think I'm approaching this mainly from the perspective of a kind of liberal legal theorist here. I know I had to get that in to get Lena upset with me. But my point is to try to say that in Sunni juridical thinking, the law constitutes sovereignty. Sovereignty is not above the law, the way some sort of crude Austinians would view it. So you have an unconstrained sovereign, the unconstrained commander. That's not the idea of Sunni sovereignty. The idea of Sunni sovereignty is manifested through conformity with law, right? Not being above it. That's sort of the really essential point. That's what allows for sovereignty to be shared across all these different offices and have a residual existence in the community members. So, for example, Ibn Nujaym, who's a 16th century Egyptian Hanafi, has a very interesting epistle about what happens when the governor when the governor dies, right? And the Sultan in Istanbul has not sent a replacement yet. Who takes over, right? Is it the commander of the garrison or is it the chief judge, right? And it goes back to, again, this idea, it really gets to sort of the idea of the exception. What happens when there's an exception to the regular constitutional order? That's where you see the real sovereign arise, right? And the real sovereign arises as Lakhmi says, and as Ibn Nujaym says, it's back in the community. Although Ibn Nujaym is very clear, it's the judge. It shouldn't go back to the public to elect somebody new. The judge should exercise sovereign powers until such time as the Sultan can send to dispatch a governor. But my general approach is to look at the details of the rule of the law, jurisdictional and procedural, to understand how sovereignty in the sense of final decision-making is normatively constructed, right?
Thanks very much, Mohammad. The issue of delegation here, because it seems that endless, everyone is a delegate, and the sovereign cannot be manifested. So anyway, turning to you, Lena, and then I notice we have questions in the chat as well, and I'm sure Usaama has some.
Yeah, Faisal, thanks. I think that you picked up exactly on what I was thinking is where the overlap is between our two presentations, which is this understanding of the pre-modern context as being one in which authority, or if you want to call it sovereignty, is more horizontal but also more shifting. And so it's not a simple linear vertical relationship between the sovereign and the state's bureaucratic apparatus that people would understand in the modern nation state framework. So I agree totally with Mohammad's presentation on those points. You didn't talk that much about liberal things, Mohammad, today. So actually, there wasn't a lot to sort of disagree. You didn't bring up Rawls for the first time in a long time. So So far we've been great. But on the second question, the citizenship issue. So the things I discussed about citizenship is based on this article that I published a few years ago on taxing citizens. And really the first criterion is political status. It's not wealth. Wealth only comes, so I wouldn't use the concept of property and all of the modern concepts related to it. Because property is only secondary to the issue of as to whether or not you're liable to pay the tax. And so the liability to pay the tax is a place where you can see how the jurists are, and I believe, constructing political membership. And the reason why this is significant is because it really changes the framework for how we understand non-Muslims in the Islamic empire. So it's not only about what it tells us about political belonging of Muslims, right? But also what it says about these semi-citizens, these non-Muslims, and what their status is. And the moment you stop sort of projecting these religious ideas that come from modern secular notions, and then rethink governance in terms of citizens' status, then everything looks very different, but it also looks more historically contextual, which is the point of the Roman citizenship comparison, because the poll tax is, as we know, was very common in the Roman Empire. So it's not as if any of these policies that we see in the Islamic empire vis-a-vis defining citizenship were somehow unique to the Islamic empire. And so that's why I emphasize it. Thanks for the question.
Thanks very much, Lena. Usaama?
So I'm tempted to let the attendees go first, if that's all right, Faisal. And I mean, I know that Ahmed Chelik put his hand up a while ago, and then we had two questions. So.
Oh, I see. Oh, yes, we have hands up as well. So shall we, I don't know which one came first.
Ahmed Chelik's hand was up early.
Yes. So Ahmed, if you want to make yourself visible and ask a question.
First, I would like to say thank you, both speakers. It was a wonderful program event. My name is Ahmed Chelik. I do PhD at Syracuse University in the religion department, and I work on my dissertation currently on, actually, the title of my dissertation is Traces of Sovereignty, multiple political layers of Islamic political thought. Particularly, I focus on al-Mawardi and al-Juwayni and al-Farabi. My question, I have two questions actually. One to Mohammad Fadel, Lena, and my first question is that based on your presentation, what I understood is that actually the sovereign power of any kind of ruler is grounded on the law, the Sharia, and this Sharia, as when I look at Mawardi and Juwayni, especially Juwayni is very clear when he says that Islamic polity and Islamic community is possible and can survive when even there is no ruler, there is no government, when even there is no Khalifa or Amir or Wali. So community can survive. And he said that the Mujahideen, then the Mufti and the scholars should take care of the rulership or leadership in Muslim community. So from here and from what you have said, what I understand is that the foundation of Islamic political thought is the common ground, or let's say epistemic and moral ground accepted and embraced by the community. In other words, it is the will and the consent of the community and their agreement on certain epistemic way of looking the world is the foundation of Islamic political thought and Islamic sovereignty. Would you agree with that, or what do you think about that? Would you like me to go to the second question?
Be quite concise with Lena's question, just so that everyone gets a chance. Thank you.
Yeah, sure. Just from Al-Farabi, what I read is that actually, unlike secular politics, especially as you emphasize the church versus state, in Islamic tradition, religion, with its metaphysical and theological assumptions, religion is a kind of mediator between politics, power, and community and people. So it's quite not opposite, but so different than the European historical experience. Would you agree with this role of religion, like mediation between politics and political elites and people and community. Thank you so much.
Thank you very much for your question.
So Ahmed, thank you for your question. I think what you said, I largely agree with. I'm going to point out that a friend of mine, Ahmed Abdel Majid, published a very interesting paper about Juwayni in the European Journal of Political Philosophy, I believe, which talks about Juwayni and the exception in Islamic political thought. And I think he uses the concept of the common sense sovereign as sort of Juwayni's ultimate account for how Islam survives in the absence of an organized state. That there's this idea of the sovereignty of the average person to understand the basic requirements of the law, and that it can survive through that common sense sovereign. Now, I think this is actually a really important theme. It's something I've talked about on other occasions that you see in Ghazali, although Ghazali, he's very Protean himself. But in this argument that he makes, in the context of defending the Abbasids against the claims of the Ismailis, he resorts to this idea of a common sense sovereign, saying that the Ismailis claim you need to have this impeccable imam in order to live a life pleasing to God. And Ghazali says, no, you don't. All you need is to have a basic sense of moral uprightness, not perfection. And then you can study the law and live reasonably by it. You don't need an impeccable imam. You just sort of need kind of like I call it tongue-in-cheek, adequate amount of virtue. You don't need to have a sort of a perfect or superheroic amount of virtue. Adequate virtue is more than enough. And adequate virtue is present among any sort of normal community of human beings. And so that has its own assumptions about human nature and about God and about what God demands of people. And just to go back to my presentation, it's interesting that when Malik talks about the legitimacy of decisions of arbitrators, rulers, or whatever, he doesn't talk about them being correct in their decisions. All he says is that their decisions should not be manifestly unjust, right? So it's the same kind of idea. Again, tongue-in-cheek, I talk about Sunni political thought as a republic of adequate virtue, right? That's sort of the desideratum, adequate virtue, not anything more, but the belief that human beings are capable of achieving that level, on their own, essentially, in a post-prophetic world.
This reminds me of Patricia Kroner's remark about Sunnism, about being, let's just do the best that we can, kind of being the ethos of Sunni political thought almost. But I wanted to hand over to Lena. You had a question directed towards you. You have a question directed towards you in the Q&A. So please feel free to, we'll get to that in just a moment as well.
Okay, so thanks, Ahmed, for your question. I wouldn't use the word religion to describe anything in pre-modern Islam. I use the word tradition. So did Muslims in the pre-modern context think that the tradition was a way of mediating between community and politics? Yes, absolutely. I don't think that that's a stretch of the imagination. So that it's an easy answer, basically. Do you want me to answer the next question? I saw it.
You mean Alex Hanley's question? Okay, yeah. So, and I also wanted to point out, a number of your interlocutors for both of you are in the call, or the people, in the sense of, Ibn Nujaym was mentioned, Sami Ayyub's here. The question of religion that comes up with Alex is also something that Rushain Abbasi's talked about. He's in the call. Andrew March is here, who's obviously sort of for sovereignty in the modern period. So I think that I just want to welcome our colleagues and say that if you'd like to interject as well, I'm sure Lena and Mohammed will be more than happy to. Lena, do you want me to read the question, or would you just so that you can respond to it?
I can read it, it's fine.
Please do. Right.
So if religion is a problematic category for pre-modern history because it is a modern secular invention, what about politics? Do you think there may be problems with talking about Islamic politics? So Timothy Fitzgerald very famously has written about this issue, and he rejects the category of politics for these reasons. This is why, though, I disagree with him about this. And this is why I gave a definition of politics as being matters of governance. So I gave you a transhistorical, transcultural definition of politics, not an essentialist one, but one that is that functions basically across time and place. And I made a distinction between secular politics and politics writ large. And what I said very specifically is that it's secular politics that distorts understandings of pre-modern Islamic political thought. So I don't have a problem with the category of politics itself.
Can I, if Faisal, you'll allow me to as well, if I can just sort of pick up on the point that you've just made, Lena. I mean, do you have any thoughts on using categories that are indigenous to a tradition like deen and saying that this is close enough to influence our understanding of how we should conceptualize religion, kind of what Roshan Abbasi's done in his work, and something akin to what I'm trying to do in future work as well?
My article, Decolonial Translation, explains why the translation of deen as religion is wrong, and it didn't begin until the modern era. The usage of the word was understood to mean tradition or law. We can see this in translations of the Quran into Latin and to other European languages in the medieval era. The word religion was not used. More importantly, the word religion, the concept of religion, is a modern concept, and it's defined by secular ideology, which is a modern concept. So I've explained this in many articles, so I don't really want to go into this issue again. It's important for us to differentiate between concepts that are transhistorical and transcultural and concepts that are actually modern and Eurocentric. And for me, having studied the history of secularism and the genealogy of religion, I find it difficult to believe that anyone would take the word religion and think that that can somehow be transhistorical and transcultural when there is an enormous amount of scholarship by very good scholars showing that the word religion, the concept of religion, not the word, because there's a difference between terms and concepts, but that the concept of religion can somehow be found in pre-modern texts. It cannot. But that's really not the point of today's discussion. So I would just say, read my Decolonial Translation article and my blog post on Eurocentrism of secularism.
Can I just,
Please.
I'm just going to gently disagree with Lena, and if I don't want this to go off the rails about this.
I know, but this is where we've disagreed before. I
know we disagreed vehemently about this, but I'm just going to throw this out there for the benefit of others, since this came up. I think Jeffrey Stout has a very interesting series of lectures that he gave at a British university, I think the Gifford Lectures, on natural religion. There's a series of lectures on natural religion where he certainly gives an alternative genealogy of the term religion. And he makes a distinction between religion and faith. And he identifies the idea of faith as being born in the sort of as being the particularly Protestant Reformation idea, which he says is a very distinct idea from religion. And he says religion, you find, go back to Roman authors like Cicero, and that religion is just considered a virtue. That, you know, and even medieval writers prior to the Reformation recognized religion as a kind of civic virtue that is not particular to creed, right? It's the Protestant Reformation that introduces this new idea of faith, which is sort of irrationally tied to conscience, that begins sort of the radical transformation of these things. Now, one final point in the Islamic context, because I read Lena's essay very carefully. You know, Tahanvi, in his definition of, in his encyclopedia Kashaf Istilahat al-Funun, in his definition of deen, one of the definitions he mentioned is aqaid. So it's not just law, it's not just practice, it's also subjective beliefs, but I don't want to go into all this.
I never denied that, Mohammad. That's not the point. The point is whether you can divide those into separate categories. And it's the division that is modern and Eurocentric and a result of secularism. And it didn't pre-exist secular ideology.
In any case, I don't want to, get into that
well,
debate.
Mohammed, before you sort of mute, I'm going to direct the next question at you.
Okay.
Before I come back to my own questions for both of you. But Faisal, if you have further questions, please feel free to jump in. So anonymous attendee in this case, saying Professor Fadel mentioned how pre-modern governance was sovereign because of its ability to establish rule of law as opposed to vice versa. Does he liken that to the modern state in that regard? Postcolonial scholarship argues that the modern state typically establishes sovereignty via a monopoly of violence. How is that contrasted or likened to pre-modern Islamic governance?
Well, if you look at somebody like Mawardi and his description of the incidents to the contract of the caliphate, he notes that having a monopoly over coercion, more or less, is a necessary incident of the contract. Now, he doesn't use that phrase. What he says is that in contracting the caliphate, we agree to divest ourselves of the ability of enforcing the law, right? And so there is a distinct crime in Islamic law called iftiyat, which more or less can be translated as vigilantism, right? So again, but it's complicated because in some cases, jurists permit self-help if it can be done without a risk of violence. Where there is a risk of violence, then it's forbidden and it can be punished, even if it's substantively correct. So if you look at chapters on retaliation, qisas, right? At least the Malikis are quite clear that you might have a lawful entitlement to exact vengeance on someone, but you can't do it until the person is actually convicted and you get permission of the ruler. Otherwise, you've committed a crime, right? So there is this idea that the state has a particular claim to rightful use of coercion, right? And that's a necessary incident of sovereignty. But that's not the whole of it, right? Because it's got to be used in a lawful way.
Right. And I mean, this would seem to make a fair amount of sense within the logic of any kind of political enterprise or a state enterprise, that once you sort of like distribute those final decision-making opportunities, you've distributed sovereignty to an extent that may, begin to divide the identity of the state to a certain extent. I don't know if you would agree with that, but it would seem that what we talk about as the monopoly of violence is something that is very much detectable within early Islamic law.
Well, I think what I would say in terms of dividing the identity of the state, I think the whole point of Qaddafi's book is to show why that's not the case. Because when people are actually exercising genuine sovereign authority, that means everybody else has to recognize it, right? And so and this is at the highest level and the lowest level. So when the tax collector collects taxes and that decision is viewed as a valid exercise of sovereign power, then everybody else in the community has to recognize it and can't contest it on the grounds, well, I disagree with your interpretation of tax law, for example, right? And so despite the fact that sovereignty is distributed, because it is sovereign, there's unity and universal recognition, at least according to Qaddafi. That's the whole point of giving it the legal authority of sovereignty, because now everybody's compelled to recognize it as final, even if you disagree with it. That's what it means to have a sovereign authority. Your decision is recognized as valid and binding on everybody else.
Thank you. So Faisal, if you would like to ask anything, please feel free. But
no, I was just reminded, Usaama, of a previous seminar in which Negin Yavari made the argument that sovereignty was impersonal in pre-modern Islam, which seems to align with what Mohammad has said. But she also went further, you will recall, to suggest that, which I thought was very interesting, that one of the implications of this impersonality had to do with the fact that even the offices that can be variously sovereign, and Mohammad has mentioned them all, may not be able to encompass the idea of it, so that it is always possible for any individual to lay claim to a sovereign act in the absence of the action of the authorities concerned. And so I wanted to ask both Mohammad and Lena, actually, what room they see existing for, we don't have to use the term sovereignty. We can use, Lena's, authority, political authority outside the designated offices of a Qadi, Imam, Wali, etc., Caliph, Sultan. And this brings me back to my early, somewhat in jest in a way, suggestion of an anarchistic mode of politics. Is there something to it? Is it possible to think about legitimate, but not necessarily legal forms of either sovereignty or authority in this pre-modern world?
Go ahead, Mohammad.
Oh, I thought that was for you first. I think this is what actually makes Islamic political thought very modern. So Martin Laughlin in England, I can't remember, I think he's in King's College in London. He's a political theorist, constitutional theorist. He points out that it's an essential attribute of modern sovereignty that it's always contestable. That's what makes it modern, because it's based on a principle of legitimacy that is always contestable. And that is what gives Sunni political theory incredible instability, because it's always possible to challenge it as being unlawfully exercised. So a jurist that I've read a lot when I was studying Maliki fiqh, an 18th century Maliki named Ahmed al-Dardir, who was a very prominent Sufi, he is extremely anti-Ottoman. I mean, it's kind of shocking how anti-Ottoman he is. He said in many passages in his work, he says, these are the rules that apply if there is a hakim shar'i, but there isn't a hakim shar'i in Egypt, right? And so it devolves. So this is the rule that applies, right? I think the other commentator is absolutely right that there is always this potential for someone to claim sovereignty, because as I said, the sovereign is immaterial. It's the Muslim community that's an idea. It's not embodied in any person. No person can claim to embody it. Now, one thing that I would just want to clarify, this is only one tradition. This is the juridical tradition. The juridical tradition is impersonal. But at the same time, particularly after the Mongol invasion, you have a completely different ideas of political legitimacy that are coming from Central Asia that are very personalized, right? And I think the Ottomans have a lot of sort of schizophrenia in their legitimate, the tactics of legitimation they employ, right?
So Hussein Yilmaz, who's in the audience, was one of our speakers who spoke precisely to this, the Ottoman claiming of the caliphate and what it entailed. But Lena.
Yeah, so I think we do agree that political authority was something that was the object of competition, interaction, overlap, that there were multiple groups, not only jurists, but other types of scholars who were competing for forms of political authority. I always get uncomfortable when I hear essentializations. So the claim that somehow modern sovereignty is contestable, as if pre-modern sovereignty was not, would for me be problematic, because I think that what we should always do is look comparatively and contextually and historically. And so nothing that I've said today about the Islamic tradition is specific really to the Islamic tradition. I mean, there are analogies or comparisons that I can make to the Jewish tradition. There are things that I could say that are similar about other traditions. And the key issue is the ways in which the isolation of the Islamic tradition as the contemporary liberal antithesis then implots the narrative in a particular way. So part of what I was pushing back against when I made the comments about the church versus state implotment of the narrative is that the ulama, the scholars, have become like this kind of cemented church configuration. And we hear it also with the ways in which we constantly hear the great men. They're like the popes. Like we hear the names of these great male scholars constantly. And actually the picture in the pre-modern context is far more diffusive. There's a lot more people competing. And it isn't the case that it's Mawardi or Juwaini or others who are defining what political thought is for the entire society. There's actually all of these jurists and all of these low-level bureaucrats and all of these other people who are participating in this process. And they have certain claims, and the caliphs, of course, and they have certain claims to political authority that have to be recognized, I think.
If I can sort of briefly ask Lena yourself a question, but it ties in with something I wanted to ask Mohammad as well. And to a certain extent, it ties in with the work of another of our colleagues, Andrew March, who's on the sort of Zoom call, which is that you have also the way in which contemporary Muslims will draw on that tradition in order to legitimize certain types of political practices. So, and this is where I struggle a little with sort of a critical theoretical approach, or whether it's deconstruction or post-structuralism and so on, which is extremely useful for poking holes in the sort of like hegemonic narratives or meta-narratives that we are used to hearing, and which I appreciate, Lena, your sort of desire to really take the sledgehammer to whenever possible. But when it comes to the question of constructing an alternative to, in the Middle East, for example, the context where there's authoritarian rulers who draw on the Islamic tradition also to construct their own sort of stories of legitimacy. What sort of constructive stories are possible to, like, what is your thought on the way in which someone like Andrew March provides this, great man history narrative, admittedly, of the rise and, this is a question to Mohammad as well, the invention, as Andrew puts it, of sovereignty, sovereignty of the people as a modern idea that then legitimates democratic sort of practice, which many of us would think is very important, actually, in the sort of in the Muslim world, considering certain circumstances there. Although, I mean, taking into consideration the problems that are endemic to democracy as practiced in the West, which Salman Sayyid colorfully describes as Western plutocracy rather than Western democracy. Bearing that in mind, what sort of constructive projects are possible, and what do you think of this kind of narrative of the creation of sovereignty of the people? Is that's something I actually hear resonances of in what Mohammad you've said today?
Okay, so first I have to make a comment as a critical theorist that this kind of critique as being only deconstructive is problematic when it's not actually based on specific examples. So all of my work is both deconstructive and reconstructive. The odd number chapters of my book are deconstructive. The even number chapters are reconstructive. When I talked about the charity taxation, I gave you a deconstructive perspective on this category of religion, and I reconstructed the category of citizenship. When I talked about the macro history, I gave you a reconstructed macro history first, and then I deconstructed and told you that the church versus state narrative is problematic. So to begin with, I have to say, I think that what happens a lot with audiences and a lot of readers, especially in Islamic studies, is that they become so uncomfortable by the deconstructive aspects that they become blind to all of the reconstruction I'm doing. And so there's always reconstruction, that's part of it, so it is there. And on the specific issue of how you do the reconstruction when you're talking about modern political thought, or modern, in my case, legal thought, I've done that very explicitly in my article comparing Islamic and international laws of war. I mentioned that in the end when I talked about the category of secular Islamization. So I think that there are very clear ways of articulating, but the kind of modern dynamics that you're talking about, but the articulation of those modern dynamics has to be based, from my perspective, on analytically rigorous concepts. And so what I see in the scholarship on modern Islamist politics is a lot of essentialization, a lot of conflation of orthodoxy with the Islamic tradition, a lot of inability to differentiate different concepts and categories. So when contemporary actors draw upon the tradition, as I said in my talk, they are making interpretations of that history. They're not necessarily narrating to you historical facts. There's a difference between what we as scholars do and what historical actors or historical agents claim they are doing, or contemporary actors or agents are doing. But we have to be critical in our assessment of what they claim to be doing. So I don't know Andrew's work on the invention of sovereignty of people well enough to offer a critique. But I don't have any specific comments on that. All I'm saying is that for me, what I see over and over again is scholars of modern Islamic politics basing themselves on the shaky foundations of misunderstandings of pre-modern Islamic political thought. And so what I pointed out is certain ways in which they make presumptions about a church versus state controversy. They make presumptions about the applicability of the category of religion that then has implications for how they're assessing modern Islamic political thought.
Thank you.
First of all, I think all acts of construction entail creative destruction.
Yeah.
And you don't even need to be a modern Muslim to see that. I mean, if you look at the work of a 5th century jurist, the way they read their forebears from 3 centuries earlier, I would describe it as acts of creative destruction, right? In the Schopenhauerian sense, right? You're transforming your material as you're reproducing it. So I don't worry so much about whether modern thinkers are distorting some kind of historical past. I mean, I think that's inevitable in what constructive work is all about, right? Because you're always speaking to your own moment. And the question is, are you using, as a, from the constructive perspective, are you working creatively with your materials? Is it something that looks like, is it going to be something that at the end of the day, people are going to look and say, wow, this is a beautiful work of theory, for example, we're talking about theorization, or is it, like a Frankenstein, where it's just put together, that's what we say, talfiq, that modern Islamic law, what's the problem with it? It's talfiq. It's an aesthetic criticism that it doesn't look like a well-ordered system of law. So there's a kind of repulsion to it for somebody that has a juristic aesthetic, right? And so a construction is successful when people sort of look at it and see it, and oh, this is an integrated whole. It seems to work together, right? It's not really, it doesn't succeed because it's reflecting accurately the past. It's succeeding because it transforms the past in a way that readers find persuasive, or the people who engage with it find it persuasive, right? And I think that's a critical thing for, now I say, as a Muslim intellectual, it's really important. I mean, part of being colonized is that you're not entitled to actually engage in reappropriations of your past. I mean, I'm a Canadian law school. My colleagues who do Anglo-American law are perfectly entitled to talk about the common law as, and go back for hundreds of years for finding rule of law, right? Like the Magna Carta. I mean, we really believe this myth that our modern liberties come from the Magna Carta. Fine, whatever, right? But why is it somehow outrageous when contemporary Muslim thinkers seek to appropriate their own tradition? Why is that then sort of characterized as the most reactionary project on the planet that must be bombed out of existence? I mean, literally, right? And so there is, I think, a real politics to this, right? That there has to be space for legitimate Muslim constructivism, right? I mean, criticize it in the way you would criticize anything else, but it's kind of crazy when you think about the fact that people really think you're going to solve terrorism by banning Ibn Taymiyyah. Seriously, I mean, let's think about that, right? I mean, serious people actually believe this, right? And so if you take Ibn Taymiyyah seriously, you engage with him, as a Muslim, you are actually taking the risk of being identified as an extremist and a terrorist. I mean, it's kind of insane.
These reflect the sorts of constraints, of course, which we've been working under, in a very striking way for the last 20 plus years. But in some respects, I mean, this, I'm going to use this as an opportunity to highlight that Lena does a lot of work in decolonial theory. We live in the sort of like shadow of 500 years of colonialism. And in many respects, everyone here is extremely privileged to have always been at, esteemed, globally recognized universities, but which were also complicit in that sort of process of colonization. And That's it. I really sort of like am heartened by your complaint, Mohammed, that you know, there needs to be sort of more of a space for thinking about these sorts of things without the security state sort of bearing down upon us. I had sort of other questions and reflections, but I'm a bit conscious of time. We've got 6 minutes left. I did want to ask if anyone has any final questions, please feel free to ask. Faisal, I didn't want to hegemonize the remainder of the discussion. So really up to you what we do next.
No, I just think if there are no further questions, I mean, in a way, what's come up in the last few comments is the issue of context, and so and whether it is the great man theory or what can contemporary intellectuals actually constructively get from their past. These questions seem to circle around the, if you will, Quentin Skinner claim of context being absolutely crucial for thinking about a political thought. And of course, in some ways, this by default renders everything that's non-Western European illegitimate. It cannot be described as political thought because very often the intellectual context is fragmented. People are not reading the same things. There's been a gap. All of those things. Now, as Mohammed suggests, whether or not actually even Western European political thought can be understood realistically as being wedded to a context in the way that Skinner suggests is a separate question. But I wonder whether context taken in that sense might actually prove to be counterproductive. How might it be possible to think about political thought in a way that is not bounded, which is not to say that we don't historicize or that we don't do what Lena very correctly says we should do, which is make the distinctions between pre-modern and modern, past and future, etc., as visible as we possibly can. But rather that even if we are thinking about, say, either pre-modern or modern intellectual history or political thought, without having to translate from one to the other, the fact that we don't necessarily have a Skinnerian type context of continuous or apparently continuous thinking, it might pose a problem, but it might actually be an opportunity as well. And I just wonder sometimes whether some approaches to thinking about great men, and they are always men, sadly, as voices projecting from a period or a past, is in some way a kind of rearguard action of a retrofitting context in a minimal way around an individual, because it's not so available in a more general form. Anyway, just some thoughts. Lena, I don't know if you have any comment on that. I see there's a question on chat as well.
Yes, so I think that there's, I take your point completely, which is that there's always a certain amount of danger to contextualization, because where does the contextualization end, and what contextualization is included and what's excluded, right? Because it's actually an act. It's not a passive sort of thing, right? It's constructive in a very clear way when you define what a context is. But I use contextualization to mean historicism, and in my case specifically radical historicism, as a way of understanding genealogy. So as I think Faisal and I agree, religion has a colonial genealogy. We know that the concept of religion was disseminated throughout the world through colonialism. And so rejecting the category of religion is an anti-colonial move. This is why decolonial theorists recognize religion, like the categories of race, ethnicity, and gender, were articulated in colonial contexts in particular ways. But there is a question in the Q&A that I'm going to try to answer.
Please do.
If that's okay.
As we come towards the conclusion, please
do. So the question is basically, what does the contemporary Western Academy specifically in terms of who works on Islamic legal theory, miss when it comes to critical theory. So I can answer this very simply, which is that scholars who work on Islamic theory, legal theory, or scholars who work on Islamic law basically don't have critical theory training. So there is no critical theory in the study of Islamic law today. There basically isn't anything. So they miss everything. I mean, but that's, as you also saw in this discussion, if you're starting from a critical perspective, then you're going to reach an impasse very quickly where you don't have a place to agree. So if, for example, we can't agree that religion is a modern concept and that it's colonial, then the discussion stops at some point.
Yeah, that's as appropriate a time as any to actually close the discussion. Yeah. But Usaama, if you do us the favor.
Sure, and I apologize if my 3-year-old in the background makes a bit of noise, but I really am grateful to both of you for a at times rather spirited discussion, and I think all the better for it. I look forward to you both sort of joining us in person at some point. Well, I mean, in the case of Lena, we have the pleasure of having you for a few more years. I also wanted to just say that this is the last of this term's seminar series. We're going to resume with another 5 seminars next term. These will be advertised, I hope, within the next couple of weeks. So please keep your eyes open for that. If anyone is interested in watching the re-recordings, please go to the YouTube channel for the Middle East Centre, Oxford. They will be put up there. And if you'd like to be on the mailing list, obviously have a look at the St. Antony's College website. The events will be up. You can register there, but you can also write to myself and I will sort of pass your email on if you'd like to be on the mailing list. But thank you very much. And thank you, Faisal, for really sort of bringing this together, suggesting this as an idea. So it was Faisal's idea. He was the evil mastermind behind all of this, and very much appreciated. And thank you, everyone, for your attendance and participation.
Thank you all. Very nice to see you, Mohammad, Lena, and Lena, I hope we can meet soon.
Yes, have a great day, everybody.
Thank you.
Take care.
Bye-bye.